So welcome everyone, and sorry for the delay. We will be having a session today, a webinar about tenant rights and obligations. And as mentioned, we have, if you need that interpretation in different languages, we have the Chinese, Arabic, Somali, and Spanish. So please join the interpretation session, a room that you need to join. And we will be recording all the sessions. If you have any, don't want to show yourself, please don't show your screen, close it. And welcome to everyone from the Tenants Office, the New Brunswick Coalition of Tenants Rights, and Jael, you're welcome to start, please. Thank you so much.
Thank you, Charbel. Thank you for Multicultural Association also for inviting me. I'm gonna speak slow, so to make easier for the interpreters. So yes, I'm Jael Duarte from the MB Coalition for Tenant Rights. I'm talking from the unceded territorial Wallostic. I'm also a lawyer surveyed by the Law Society of New Brunswick. I can't answer in public, so in a webinar, particular questions for question of confidentiality. So at the end of the presentation, if you have a question, if someone have a question, please make the question in a general way so I can answer publicly. If not, so you can see, I had my, well, at the end of the presentation is my contact information. So I'm going to start.
Giant, please, when you're speaking, just it's not only the speed, if you can just give sentences, so to give them time for the interpretation, so they interpret the sentence.
It's true. Thank you. Thank you
okay.
for that. Yes.
Sure. Thank you very much.
So I'm going to start. The legislation applicable for tenants and for lease for anything related to is the Residential Tenancies Act in New Brunswick. So there is a situation here in New Brunswick, a little bit difficult. So in New Brunswick, at this moment, there is no rent control. That means the landlords can raise the rent, the amount they would like to. In the legislation, the current legislation, there is a percentage. So I always suggest to tenants, when there is a rent increase, it's important to reach out the tribunal. We are going to see in this presentation how to reach out the tribunal. The tribunal is a tribunal for residents for tenancies, and this tribunal is the institution meant to mediate and make decisions about rent. In the legislation in New Brunswick, it says that normally and almost every time the tenant have to make a complaint or have to address their questions to the tribunal. So you are going to see what kind of questions, but always by default, go to the tribunal. If you have a question, if you ask the landlord, for example, fixing something at the apartment, and the landlord didn't do on time or something like that. There are recent changes. We are going to see that changes in the legislation, but unfortunately, that do not stop rent increases. And there is also confusion, and we are going to see that in this presentation. That is making situations sometimes really difficult for tenants. So in December, it was a change in the legislation. Before, only long-term tenants could be revised. Now, all rent increases can be revised by the tribunal. At this moment, the notice period, that means when the tenant receives the notice of increase, it has to be that the increase is happening 6 months from the notice of increase. For example, someone received the notice in January. The increase of the rent is gonna take place in June, 6 months further. It has to be like that. To allow more time, it says the legislation to what it was said by the government to allow more time to adjust for the tenant. Still, it can be, there is no limit in this change for the rent increase. Since the tenant received the notice, which have to be a notice with the name of the tenant or tenants. That means, for example, and sometimes husband and wife are in the lease, in the contract. So the notice has to have the two names. If husband and wife, for example, are in the contract, the notice has to have the address of the apartment, of the house, and also, of course, saying 6 months, in 6 months is going to be this amount of increase. So since the tenant received the notice, the tenant have 30 days to request a review of the rent increase. That means 30 days to go to the tribunal. So if you received a rent increase or you receive a rent increase, go to the tribunal by default, I always say. What is going to be examined by the tribunal? The first thing the tribunal with a rent increase is going to see is the form of the notice is in accordance with the law. As I say, that means the notice was served 6 months before the rent increase was announced. if the landlord increased the rent for each comparable unit at the same building by the same percentage. This part is gonna change, and it's changing now with a temporary rent cap. We are gonna talk about that further, but at this moment, it's important for you to know that there is a temporary, so this year, January to December, a limit of the rent increase. So New Brunswick have few protections against eviction. At this moment, landlords can evict at the end of the lease without cause. That is changing too. And we are gonna see how. But at this moment, it's only the justification for tenants after 5 years. It is important to note that rent increase are also an eviction by another name. Why? Because normally the notice of increase is made at the same time as a notice of termination of the contract. So what is happening now is that the landlord make the notice of increase and say to the tenant, if you don't accept this increase, you can leave, which is not really a choice. So we are going to see that there are changes in the legislation coming, not yet enforced, but coming, which will put limits on that. Okay, we arrived. A bill, it is a law still in the assembly, the Legislative Assembly of New Brunswick. So they are discussing the law, but it's not still a law. At this moment, this bill, it is in the last stages of discussion. So it's probable that it's gonna become the law. If you remember, I said that this bill is causing confusion. So I'm gonna explain, and in case of doubt in your particular case, always go to the tribunal.
Excuse me, Jal, can I just ask a question, please, about this rent cap?
You could write your question in the chat or at the end of the presentation.
Okay, thank you.
Thank you. So the rent cap, as I said, it is a limit in the rent increase. So at this moment, it is only between January 1st, 2022 and December 31st, 2022, with a limit of 3.8%. So if you received a notice of increase at this moment for the increase in January, so even if the notice of increase was before January, but it took effect after January 1st, 2022, So you have right at this rent cap. As I said, it's a bill, but also the tribunal has been publishing in their website this. Actually, this information I kindly copy pasted from the webpage of the tribunal. So even if you overpaid, if you think that you are paying more of this 3.8%, so once the law is enforced, this amount will be credited on your next rent payment. If you left the apartment of the house because this rent increased, but you still was paying, this amount, the overpayment, will be reimbursed. So at this moment, if it's the first time you are hearing about that and you are in this situation where you received a rent increase over the 3.8%, or even if you have the doubt, maybe not, I encourage you to go to the tribunal and ask for a revision. Still in the bill, it will be a limitation on the landlord's right to terminate. So as we saw before, it was at any time for the landlord to terminate the contract. When, and hopefully this bill is gonna take effect, the landlord can't serve a notice of termination unless they provide a proof that a family member or a spouse is moving into the unit. The unit is going to be turned in something non-residential, for example, a commercial. The unit will be renovated to the point that you can't live there while the renovations are occurring. This point is important. It's what we are calling at the coalition and many times the renovictions, because before it has been so common from landlords to say that they needed to renovate the building, and for that reason they terminated the contract. Now they have to justify that the tenant, that it's impossible for the tenant continue living at the building. If you, another possibility to terminate the contract from the landlord side, it is if the person is a superintendent for the landlord and the employment is over. So when the landlord wants to terminate the contract, as I said, and please remember, it is a bill, not a law yet, the landlord has to apply to the Residential Tenancy Tribunal in order to serve this notice. If the landlord is renovating, they need to start the renovation within 2 months. If they don't, and the tenant catch them, they can apply, so the tenant can apply to the Residential Tenancy Tribunal for compensation. That is important. So that is why I also always recommend to keep receipt, because in order to prove that you have a right for compensation, and mostly the amount of the compensation, it is important to prove. So, for example, in this case, The landlord wanted to renovate. The landlord demonstrated to the tribunal that the tenant can't continue living in the apartment while the renovations. So the contract is terminated, allowed by the tribunal. And the tenant had to move. So the expenses moving. The changes, it's important. For example, if the children had to change school because of that, it's becoming more expensive to arrive for work because of that. I'm just giving examples on how you can show the amount for the compensation. Maybe something more tragic, like how that causes, the move causes more and even more difficulties for your family. Maybe you were in a situation, maybe a family member who was sick at that moment. All that is important to demonstrate when you are asking for compensation. I was just giving examples. So pay attention to this. So if your notice or termination was served any day after June 2nd, it's void, it's not valid. If not, doesn't have one of the reasons I described it. If you received a notice of termination after March 22 this year, but before June 2nd, the tenants can apply for the Residential Tenancy Tribunal for compensation. So if you are in this situation, apply to the tribunal for a compensation now. I will say you can't start your case. As I said, the tribunal is already promoting these changes, even if there is a bill still. So I encourage you, if you received a notice of termination after March 22 this year, to apply to the tribunal for compensation. So how to file a complaint? You have to submit a written request to a residential tenancy officer. Where are they? They are at Service New Brunswick. So there is, if you call to Service New Brunswick, they are gonna give you the option for the tribunal. You can call and ask questions to the person in charge of the tribunal, but that questions are not a complaint. The complaint has to be written. Sometimes it's helpful to call to write better the complaint. Sometimes you don't need to call, you just write the complaint. And I will say, because the person answering the phone may be a different person, a different agent assigned to your complaint, I encourage you always to write a complaint. Because as we saw for the rent increase, there is only 30 days. And we don't want to lose that opportunity. For any other complaint, for example, the termination of the contract is only 15 days after you received the notice. you see? And obviously, March 22 is more than 15 days at this moment, so write the complaint. You can apply online, so you can go to Renting in New Brunswick website. You can just Google Renting in New Brunswick, and you will see the forms to complete. You can also print it or send to the email, send to fax, or even print it, sign it, and go to a Service New Brunswick location. What is going to happen? If it's something urgent, for example, there is a pipe which explodes in your bathroom, and you call it the landlord, and it's not, the landlord is not fixing it, and it's urgent. You apply because the landlord is not fulfilling their obligations to fix, and you say urgent in the email or in the application or even in the paper. So they are gonna, normally, they attend the request faster and they assigned an agent faster. So now it's time for questions.
Thank you so much, Jael. I've been quiet for some time.
Well, I believe Sheila, she said that she had a question. I don't know if she wrote in the chat or maybe she wants to do it.
No, I'll have to look back and digest that. Thank you so much.
Does anybody have any specific question or some clarification?
I have a question, please.
Yes.
I want to ask if the landlord have a right to evict the tenant after 5 years from the apartment or house. If he delayed, the tenant delayed on payment, but he stayed 5 years in this house, is the landlord have the right to evict this tenant after 5 years?
Good question, thank you. Well, there is when the tenant don't have a delay on payment. No, I'm gonna start by the other way. An eviction, it goes after a termination, and an eviction is a process at the tribunal. So eviction is different than termination of the contract. That is important to differentiate. Eviction is an eviction notice with a sheriff assigned after a process at the tribunal. So there is no surprises in evictions because normally, and it has to be a process before at the tribunal. So to answer your question, if the tenant didn't pay or had a delay on payment and the landlord wants to terminate or make a notice to terminate the contract, depending on the contract, but normally the person has 7 days to pay and it's okay. After the termination and saying, this is what you owe me, but in 7 days. Still, I encourage to reach out the tribunal. Why? Because the tribunal is also a mediator. I know it's confusing but the law is confusing. So we called the tribunal, but there is a stage of mediation. So the tribunal is gonna mediate with the landlord and the tenant in order to pay. Also, if after this process, definitely there is not an agreement, so maybe the agreement, it could be given the tenant more time to pay, or more time, or a time to leave the apartment, for example. If there is a broken, if the disagreement is broken, so then the landlord can pursue an eviction, but it's a process. So I hope I answered your question.
Yes, but if the landlord don't agree to pay on 7 days and insist to evict the tenant, so the tenant can go to claim and take compensation for this.
The tenant, which the tenant will do, is ask the tribunal to mediate. The
Tribunal,
wait. The tenant will ask a mediator to have more time. There is also another important authority you can go, and I encourage going. It's if in the family there are children or a child.
yes.
So go also to the child advocate. Involved the child advocate in your complaint, because the child advocate can help you to fix that, to help in this mediation, to have more time, or for the landlord to accept the payment. For example, I'm going to send in the chat the link for the child advocate. Also, if there is a person over a senior in the apartment, person over 65 years old, so I also encourage you to go to the senior advocate and involve the same. They can help in this mediation to have more time, for example, to pay, to convince the landlord, and to help in this mediation. Okay, oh, I lost the chat. I don't know what I'm doing now. Okay, I found the chat.
That mean the landlord don't have the right to evict the tenant immediately, or after 2 weeks. The tenant have to go to ask for time.
Yes,
to
can
pay.
go.
Yes, to pay. Also, if the landlord have paper from Service New Brunswick to evict.
Well, that is different, because if the tenant has a document from Service New Brunswick to evict, that means that it was already passed the process. So I encourage you even there to reach out the child advocate if there are children, to asking for help in this situation.
In this situation, if you ask the child they can give you more time to pay, to arrangement the payment.
So I think so. Maybe not paying, or that depends. It's really case by case. But what I'm encouraged is to show how this change moving and how it's affecting the children. So yeah, it's like at this moment, it's asking for the intervention of the child advocate. I see other questions in the chat that I would like to continue answering. I see a question. It is normal to have different rents for exactly the same townhouses. Well, it's not normal, but it's not forbidden by the law. So I see your frustration. I see that it seems unfair, but there is nothing in the law that prohibit that. There is another question that says, I have heard that it is illegal to charge a pet fee when renting. I have tried to read online and it's not very clear. I with you, is not in the law. So it's again, it's not, well, actually, let me, because I just did last week, I'm gonna, yeah, if you have a doubt and you will like, it will be interesting to go to the tribunal for yes, it's true that complaint sounds too litigious and it's not something that people want to, maybe people want to fight unless it's a big amount also. But let's say what is can be charged. It can be the amount of the rent when at the start of the lease, it can be charged the amount of the rent, the deposit, and reasonable fees related to the lease. When I was saying that in the webinar I did, I was thinking about parking, about administration, pet fee. If I would say it's not legal, a pet fee, because why a pet fee? A pet fee, it will say something in case the pet damage, but that is why it's for the deposit, you see? So sorry for this question, like this answer like that, but I was thinking out loud with your question, and my answer is no. It's not permitted, it's not by the law charge a pet fee. It's not legal. So I encourage you saying, because if it's for a damage that the pet could do in the apartment, that is why the deposit is for. See another question. A person paid a damage deposit at Service New Brunswick before renting the apartment. So how that the person can have the money back? It has to apply. It has to apply. Let me see. I can send you in the chat. There are normally, it's not the tenant who deposit, it's the landlord who deposit. And you have a certificate. If you don't have the certificate yet, you can ask for that certificate. And it is important, so when you rent an apartment, you have to see, you made the deposit, the landlords make the deposit, and they have in around 10 days, no, 3 weeks, I said, yeah, a certificate by mail to the landlord and to the tenants. So in the certificate, it's really important to verify that your name is accurate. If not, you reach out the tribunal and you say, hey, my name is not written like that. And this is really common for immigrants. Well, my name is not a common name, so I have seen in my life many spellings and pronunciations, and that can happen to you. So verify that your name and the address of the apartment, everything in the certificate is accurate. So with that certificate, all tenants named in the certificate must apply, and that is important to understand. Because as I said, many times in the contract, there are more than one person. Sometimes there is, and the most common could be a couple. So the couple each in the both names. And actually that happened to me, that when we finished the lease, we were leaving the apartment, my husband claimed the deposit. And he received the half of the deposit. So I realized it, and we realized, oh, I was also there in the contract. So I had also to claim my part of the deposit. I see another question. If the landlord want to say it was damaged, and be careful with this also, because there are certain obligations. So the deposit is only when the tenant, there is a damage for negligence of the tenant, or someone who were living, maybe a visit, for example, and that visit was negligent. That visit, you had someone and broken up window, a glass of the window. Children were playing, well, hopefully no, but this thing, negligence, I'm trying to explain what negligence means. It's not the usual of the apartment. It is normal that after 2 years, the paint is not the same as the first year. That happens. There are things that can be not the same as new, and that is the normal use. And that is not worth it for the landlord to keep the damaged deposit. It has to be, and that is why I encourage also tenants to complain when the landlord is not fulfilling the obligations. Why? Because you will have proof that the flood caused in the apartment is because the pipe was exploded, for example, and you made your good. You reach out the landlord didn't fix, and this damage is not the tenant's fault. But it's important to have evidence, to have proof. I encourage also tenants to communicate by email rather than calling, because it's easier after to show that, listen, I wrote to you an email. I said before, so this damage is not my fault. Well, there is a question here. If I rent a house, does my laptop and clothes should be insured by the landlord? No. The insurance by the landlord is to the building, to the apartment, not to the things inside. And I recognize that is confusing. It was confusing to me also when I arrived in Canada. All this insurance in my country of origin, people don't do insurance. So this was new for me too, also having all the insurance. But if you would like to have your laptop, your clothes, your belongings insured, you have to pay a different insurance. And I also think it's a good thing to do, actually. There is a question here. It's in Spanish, but I can read the Spanish, so I'm gonna translate the question and answer it. Okay, he's asking what kind of documents are required when someone is applying for rent, when the person is a newcomer in Canada and doesn't have any history in this country. That is a common question from immigrants, and it's normal that, so if someone is denied a rent because they don't have an historial in this country, in Canada, that is discrimination. That is discrimination, and I encourage also to go to the Human Rights Commission if you are in this situation, because they are discriminating. The landlord who is maybe doing that is discriminating immigrants. So I will say an historial, oh, I'm lost. No, what is it? An historial of, it could be, and I saw that too in other cases, a recommendation from an old landlord in your country of origin translated. That can be a reference if the landlord is asking you for a reference. For example, you can have a recommendation, you can have a reference from your country of origin, and you translate it. This kind of translation don't have to be neither a certificate translation, because it's just for the landlord to see a reference. Okay. I'm seeing some questions, I believe, in Mandarin Chinese, but I can't read these questions. So if maybe the person translating in Chinese can write in English, what means the question?
I think it was a message to put mute some clients. I Googled it and it's, yeah, so it's just a message.
Yeah, I have many abilities, but I didn't learn yet Chinese. Who knows?
Yeah.
Okay. Is there an obligation for the tenant to clean the inside of building on a regular basis? Is there obligation for the tenant to keep clean the apartment? But the building and keeping clean the building is obligation of the landlord. So if someone is doing that in a regular basis, that is work. so don't work for free. And more seriously, that is an obligation of the landlord, and it will be worth it to go to the tribunal, because it's an obligation for the landlord to keep the premises, that means the house, the apartment, fit for habitation, and cleaning the common areas of the building. Other question here, the insurance of the building should be paid by the tenant or the landlord. The building, the landlord. As I said before, the building, the landlord, the apartment, so the structure, the house, the landlord has to pay that insurance. The things inside, which, well, here in Canada, and that was new for me when I arrived, here in Canada it's common to rent with a microwave or with a frigidaire, with the oven, that is called chattels. I'm gonna write in microwave. Chattels. So that is part of the rent. So the insurance for that is for the microwave which came with the apartment is for the landlord. For your things, your belongings is the insurance for you. So if the leasing agent is requiring to pay the insurance monthly, first be sure if it's the insurance, but as I said, always by default, complain to the tribunal. Do a complaining written, as I said, and I know, and I, even if I'm a lawyer, I really like mediation and I really like going easy, but unfortunately, the law in New Brunswick put the weight on the tenant to complain. So I will encourage you to complain to the tribunal and ask the mediation from the tribunal in this case. Okay. So if you see, I'm gonna share, I'm gonna share my screen to show the website. So this is the website I'm talking about, renting in New Brunswick, and you will see security deposits. So there is all the information how you apply online for the security deposit. You will see evictions, so the information about the evictions, rent increase. Even here, you can, in rent cap introduced, you can see a rent increase calculator to see if the rent increase you received is according to the cap, the rent cap. Also, evictions, about evictions, while we were talking about evictions. And anything else, for example, the pet fee, the insurance, all these things, you go to solve a problem.
I have a question.
Yes.
Again, for eviction. I understand that if you have a lease for 1 year, 5 years, 6 years, it doesn't matter. The law goes in the period for payment, which is 7 days. But if you are tenant for 1 year or 5 years, it doesn't matter. That's right.
Yes. Yes.
It's just you have to pay through 7 days, for example.
Yeah, and if, for example, and it's really important, if you want to pay and the landlord don't want to receive your money, well, first you have, you can also ask the tribunal again to ask for that mediation. That is another possibility too, because if you say, I want to pay, please receive my money, so you ask the tribunal to intervene there.
Okay, sometimes if the tenant, for example, have a lease, contract lease, or for 2,000 monthly, for example, and before start the next month to pay, he paid before the time, for example, 1,000. Is this mean he paid the rent? If he paid before the time, 1,000, for example.
That is really case by case, and it is really to the tribunal. is really to the tribunal to negotiate and and as I said, if there are children involved, reach out the child advocate and you will have someone on your side to help you to negotiate with the tribunal and with the landlord.
Thank you.
Okay, I don't see more questions here.
Can I just ask one last question, Jael? First, it's Sheila Scott speaking. And first of all, thank you so much for such a great informative presentation. The only question I have is, as you mentioned, when you have questions or you have a complaint, it is the tribunal, the Residential Tenancies Tribunal that you would contact. I'm just curious, you represent the New Brunswick Coalition for Tenants Rights. Is that more of an advocacy group or what exactly, what's your role, I guess, is what I'm asking.
Thank you. Thank you for that question. I forgot to explain. Yeah, thank you. Thank you for that question. Yeah, the Coalition for Tenant Rights, it's a group, it's a collective. So I don't have anything to do with the government. So the situation in New Brunswick for tenants has been so difficult. And with the pandemic, it became everything. It's always difficult, but with the pandemic, everything became even more difficult. So the coalition was created with a group of people, a collective, so we created this job, this position as a tenant advocate, but it's not governmental. My role is only doing this kind of presentation. So education, legal education, advocacy. I bet many of you maybe hear me in the radio sometimes, also talking with government, and but also guiding tenants. So tenants can reach out to me, and well, I stopped sharing my presentation, but I can reach out to me to my email. I'm gonna put in the chat. I have also a phone number, but well, sometimes I feel like with persons who maybe are not comfortable with English, it could be easier the email. It will be the first time I changed with a person who is not fluent in English. And then, so I can guide the particular question of the person and tell the person and the tenant what they could do in that particular case.
Perfect, thank you. Thank you so much.
Thank you so much. I believe
Morning, Yael. You're a new student. I haven't met you before. I'm glad you could get here and find us on Big Blue Button.
Thank you.
I think there is.
Talk, Yael?
Hello?
so there's one question here left. I think can a tenant ask you to leave when your 1 year contract is over, even if
Want, like, good morning, and maybe just.
Yeah, I muted there was somebody on.
Thank you. Yes, I think the question is a landlord can ask you to leave, not the tenant. I'm gonna answer thinking that the landlord asks you to leave. Well, yes, thank you. Well, now as we saw, there is a change in the legislation. And at this moment, if the notice of termination is after March 22, it has to be justified. So So it has to be justified from the landlord point of view to the tribunal. If in the meantime the law becomes a law, the bill becomes a law, you are in this situation, again, reach out the tribunal. Okay, I think we are okay for now.
Yes, I think, thank you so much, Jael, and for the team for supporting you with the recording for the other languages. So thank you everyone for being present and attending the session and asking your questions. And we hope to see you again next week.
Yes, thank you. Thank you, everyone. And thank you for inviting me. I'm here, you know, my contact information to contact me if you need a little bit of help.
Thank you very much.
Thank you.
Thank you.
Have a good day. I'm gonna leave now.